Hello, good afternoon. My name is Seth Embry, and I'm a senior associate with Quadel Consulting, and I will be presenting today's webinar, this afternoon's webinar, on the Housing Opportunity Through Modernization Act of 2016. This is going to be an overview of that legislation, and we will include, or I will include, information to help you understand the provisions of the law that have come into effect already and those that have not yet. There's some very important distinctions that we will review so that you can be aware of exactly how this legislation is structured and how it is working as of today. So I want to start with going through the agenda of the webinar, and we have about an hour to get through what it really is a lot of information. And so the law itself, there's several sections, and we're not going to cover them all, but they are all included in the notes for this webinar, which will be made available on our website at some point after the webinar. So I'm going to go through the background of HOTMA, of the legislation, and like I said, I'm going to talk about the status of the implementation, and then we're going to look towards what kind of the future holds for HOTMA. So the legislation was signed into law in July of last year, July of 2016, by President Obama. And as we see here, its goal was to update and improve statutes, the I think 1937 United States Housing Act, which is the basis of really all housing assistance programs here in the United States, at the federal level anyway, most of them, I should say. So some of the law's provisions went into effect immediately, and some required HUD action before that would happen. So briefly, as I just to kind of cover what that looks like, there are 5 major sections that went into effect immediately. One on reasonable accommodation payment standards, one on the process, redefining the process to establish fair market rents, another one amending the family unification program for children aging out of foster care, so that deals with eligibility in terms of age and the term of eligibility. And then there's 2 very narrow provisions. One applies to Guam only, and then one applies to a handful of housing authorities across the country related to the PHA resident board member requirement. So we'll go over all of that as we go through here. So, as I mentioned, the law went into effect, parts of it, when it was signed in July, but there are 2 things that happened since then. The first is in October, HUD issued initial implementation guidance to distinguish for the public the sections that went into effect immediately and those that would go into effect later. And so that happened in October, and that was effective in October. Secondly, in January, on January 18th, HUD issued a notice for certain regulations that would be implemented, and the date that it targeted for implementation was April 18th. However, once the new administration took office, they issued a regulatory freeze. And so the January implementation notice is subject to this freeze, and it could be delayed, it could be changed. The effective date of the notice at this time is unknown, and therefore the information in the notice is subject to change, which means that the information we present to you today is also subject to change. So it's important for you to know that, and obviously it's important for you to stay up to date with issues, notices that come out from from HUD concerning kind of how regulations are going to happen forthgoing. So that's just a really important thing to know. And as I go through, I'll highlight what has come out through the January notice so that you know, okay, this came out in January, so we understand that as of now, it's scheduled to kind of be effective, but we'll see what happens. As I go through HOTMA, I'm going to go according to the sections in the legislation. And so the first section is Section 101, and it deals with the inspection of dwelling units. So if you have, for some reason, if you have the actual HOTMA Act in front of you printed out, you'll see that we're going through the document section by section. And so, like I said, we're going to start with Section 101. Here we have some highlights of the law. So these are like the big takeaways, and I want to give you just a couple seconds to review this because it'll really set the foundation for this section of the webinar. So as you see, these are kind of the broad strokes of this section, and some of this section has been implemented by the January Act and some hasn't. For instance, this section here has been implemented by the January Act, which again is subject to change. So one of the things that this does, that the January Act does, or I'm sorry, that HOTMA does in terms of initial inspections for HCV. HOTMA authorizes the occupancy of a unit prior to the inspection being complete. Prior to the unit meeting HQS if the only deficiencies in the unit are for non-life-threatening conditions. Now, HUD also, as we'll see, they define life-threatening conditions. But this is something new for all housing authorities to implement if they choose to. So again, if an initial inspection for an HCV unit, this also applies to PBV units. If for initial inspection there are fails that are only for non-life-threatening issues, a housing authority can choose to allow occupancy for a unit. They can also allow occupancy for a unit that has not yet been inspected if the unit was approved under an alternative inspection method in the previous 24 months. So what does that look like? Two things. PHAs that wish to implement the flexibility to allow for occupancy prior to full compliance with HQS must amend their administrative plan, and they have to include HUD's definition of non-life-threatening conditions in addition to HUD's definition of life-threatening conditions and PHA's definition of life-threatening conditions. If the PHA had a definition in their admin plan prior to the effective date of this notice, which again is subject to change. So the PHA can choose to apply this policy of allowing occupancy prior to full HQS compliance to a portion of initial inspections or to all initial inspections. So what might this look like, you're probably asking? And I thought of one good example. I do a lot of work with housing mobility programs for PHAs and HCV programs. And we're always thinking about, as we kind of design programs, we're always thinking about how can we incentivize landlords in these high opportunity areas to participate in the HCV program where, you know, previously they might not have. And so this provision, if you choose to apply it to landlords in certain areas, certain hard to use areas, hard to use voucher areas, which HUD talks about actually later in the notice, that could be one way to implement a partial amendment of your HQS and occupancy policy. So that's something to consider. So as I said, HUD in the implementation notice defines life-threatening conditions. Again, everything in the implementation notice, the January notice, is subject to change. And so we have a list of a couple of half the list here. which if you look at it, a lot of this is intuitive. HUD obviously includes on this list any conditions that they identify later, which will come out in a notice, or also any condition that your PHA has already identified prior to when this notice goes into effect, either April 18th or another date as required by HUD. And you see there's in the notice, so I have the list of items here, but in the notice there are actually a bit more detail about each item that I didn't include here just for the sake of being able to kind of, you know, fit everything into a presentation. And so you'll really want to refer to the notice for full details on all of these conditions. You'll see here the bolded number 8, deteriorated paint. So there's an exception there, which we'll talk about now. So under no circumstances can PHAs approve tenancy or allow occupancy for a unit that at its initial inspection there were lead paint hazards and the unit was constructed before 78 and the family includes individuals under the age of 6. However, later we're going to see that HOTMA also includes information about HQS enforcement, new statutes related to HQS enforcement, which require all life-threatening emergencies to be corrected within 24 hours. And they have here in the notice an exception that for lead paint hazards, the 24-hour requirement does not apply, but rather the requirements that are already outlined, which allow 30 days for remedying these the lead paint hazard, and that's in 24 CFR Part 35. So that's already there's already regulation governing that, and this notice HOTMA does not change how that operates. Okay. So some things that you need to keep in mind if you want to implement this new policy. One, you have to document that the HQS inspection did not reveal any life-threatening deficiencies. And so HUD is going to provide guidance about PHA's HQS process and how to incorporate their definitions of life-threatening deficiencies. But for now, know that PHA is essentially going to have to certify this unit did not have any life-threatening deficiencies according to the HQS inspection. PHAs have to provide notice to owners and tenants, and even though a PHA can choose to implement this policy, families will decide whether they want to move into units that have been inspected but don't meet HQS because of the provisions that I just mentioned. So that's something important to kind of let sink in. So in addition, some other things that PHAs need to keep in mind. When using this authority, using this flexibility, owners have to be provided notice of failure in writing. And if owners do not correct deficiencies within 30 days of notification, PHAs have to withhold assistance payments. And this is, even though we're talking here about how to enforce the HQS standards, there's a different section that really details HQS enforcement that we'll go over later. So just know that this enforcement applies to PHAs and owners for PHAs that implement this policy. Once the unit does meet HQS, PHAs can provide retroactive assistance payments for that time during which the HAT was withheld. PHAs also have to provide HUD with notice of their intention to adopt this policy at least 30 days before it is implemented. And additionally, because CMAP indicator indicator 11 scores PHAs on the percentage of units that pass HQS prior to beginning the lease and HAP contract, HUD will issue guidance to tell PHAs how CMAP indicator 11 will be modified, but until that time, PHA should continue to report the date that the unit is found to have no HQS deficiencies, including non-life-threatening deficiencies. So we'll see, on timing if this implementation notice goes into effect before HUD provides guidance on how the CMAP indicator 11 will be modified. But once this implementation is in effect, PHAs should just continue reporting MPIC as they do currently. So the alternative inspection. So there's already a provision at 24 CFR 982.406 that allows for the use of alternative inspections in lieu of HQS inspections. So this isn't something that's new to HUD or to agencies. But now PHAs can choose to allow occupancy of a unit if that unit, like I said before, has been inspected and approved under an alternative inspection method within the last 24 months. And so what this means is that if I'm a family and I can now move into a unit that's been approved even if there hasn't been an HQS inspection. However, PHAs are mandated to complete an HQS inspection within 15 days of receiving the RTA if they choose to allow these alternative inspections in lieu of HQS inspections. If a PHA wants to institute this policy, inspection completed under the home or low-income housing tax credit programs, or inspections completed by HUD can be substituted or can be used without approval by HUD. However, other alternative inspection methods must first be approved by HUD before a PHA decides to use those. And HUD wants to ensure that the alternative method of inspection provides the same or greater protection to occupants of dwelling units as does HQS. And so that's where they're going with this. So even though you can allow a family to move into a unit before the HQS inspection has been completed, obviously PHAs still have to complete the HQS inspection. Pay very close attention to the second bullet here, which is a change from what PHAs are normally required to do. For PHAs using this flexibility with the alternative inspection method, they have to begin the HAP contract. The HAP contract has to be executed on or before the beginning of the lease term. And the reason for this is that if the occupancy begins, the tenants move in, and then you complete the HQS inspection, but there are deficiencies, and the owner then has to be subject to terms of the HAP contract and HUD regulations concerning correcting those deficiencies. And they can't be held to those terms without the HAP contract being in effect. Okay? So if the unit, though, does not pass inspection, the PHA can't make any assistance payments until the unit meets HQS unless the PHA has also instituted the policy which we covered first, which allows payments to begin if there are only non-life-threatening deficiencies. HUD also wants PHAs to carefully consider the possibility of allowing a family to take occupancy of a unit and then there being deficiencies, and for some reason the owner either not being able to correct them or not wanting to correct them. Families, number one, will be living with HQS deficiencies, which HUD wants to minimize the time period of that possibility. But also, number two, if the owner is not willing to make corrections, the HAP contract will have to be ended and the family will have to move to continue receiving assistance. So this is a burden both to the PHA and to the family who has to now move again. And that last bullet, there's a distinction. So currently there's a mandate that PHAs that are of, I should say, a certain size, have a certain number of units, have to complete inspections within 15 days. And so the regulations pertains to PHAs with no more than 1,250 budgeted units. they have to complete that initial inspection within 15 days. Under HOTMA and under this regulation concerning alternative inspections, all initial inspections have to happen within 15 days, regardless of the size of the program under this provision. So that's important to note. Again, PHA must notify owners and tenants of the new procedures. And also, families have to be aware of the list, the PHA's list of life-threatening conditions prior to leasing, so that they can take a look at the unit and see, okay, well, there are or are not what appear to be life-threatening conditions. I'm going to notify the PHA, but I can also choose not to sign the lease with this owner. Again, that's for PHAs that are implementing this alternative inspection method policy. Again, HUD will issue guidance on the CMAP Indicator 11, how that will be modified for the purposes of this new method of this new policy. So moving on to HQS enforcement, as I've talked about. So whereas what I just discussed, occupancy prior to meeting HQS, that's been implemented through the notice. The section HOTMA on HQS enforcement has not been implemented through the notice. So HUD still has to issue guidance here, regulations around this process of HQS enforcement. But what they've done is made statutory a process to withhold payments from owners and to abate payments entirely. So if a unit falls into non-compliance, they meet these 3 criteria: that it fails inspection, the owner is notified in writing, and then within these time periods or other time periods established by the PHA, if corrections are not made, then PHAs can withhold assistance to owners while corrections are being made. PHAs cannot change the 24-hour time frame, but they can change the 30-day time frame for non-life-threatening conditions. However, it cannot be longer than 180 days. For units that are in non-compliance, PHAs must abate assistance payments. So that's after the 30 days. So if a unit's not in compliance for that initial 30 days or period determined by the agency, the PHA can, if they choose, if it's their policy, they can withhold payments. However, once that period has ended, PHAs must abate assistance payments. Payments cannot restart, as you see, until the unit is in compliance. And then the owners have up to 60 days to make corrections before the PHA must terminate the HAP contract. This section of HOTMA also provides statutory relocation benefits to tenants that have to move as a result of this process. If a PHA has withheld payments from an owner, a PHA can provide those monies to the family that has to move for relocation costs, which have to include security deposits, but can include moving costs and other things that's designated by the PHA according to your policy. As you see, PHAs can use up to 2 months of HAP withheld or abated. PHAs can also institute a policy that families have to surrender any security deposit that they receive as a reimbursement to the housing authority for the relocation assistance that it has provided. Again, HUD has not issued any guidance around how they see that process working, or regulations, and so once they do, PHAs will have a better idea of how to implement that. So that was Section 101, and moving on to Section 102, this section concerns income reviews and has provisions for both the HCV program and public housing, with exception to the last part on reasonable accommodation payment standards, which I briefly mentioned at the start of this webinar. None of this has been implemented by notice, and these provisions that I'm going to go over require HUD action. So income reviews, HOTMA sets statutory guidelines for when they occur. So this is once assistance to a family begins and then annually thereafter, but also at a family's request if changes in income or deductions are estimated to reduce their income by 10%, or if changes in income and deductions increase a family's income by 10%, a PHA can mandate reexaminations. For the project-based voucher program, annual income reviews are no longer required. Annual reexaminations also do not apply to certified fixed income families, which are required to have those once every 3 years. HOTMA also talks about calculation of income. PHAs and owners must use the estimated family income of the previous year for the upcoming year at initial review. PHAs can make adjustments to prior year income. Once reexaminations begin, PHAs can make adjustments to prior year income as they consider appropriate to reflect the current income. PHAs will now be able to, once again HUD issues some kind of guidance or regulation, PHAs and owners will be able to rely on income determinations by other federal means tested assistance programs such as temporary assistance to needy families, Medicaid, or SNAP benefits, also known as food stamps. HUD will be working with other federal agencies to ensure that PHAs have access to these income determinations if they choose to implement this policy. HUD has made a change in how income from assets is counted. Actual income is still counted the same, but imputed income from assets is only counted to the extent that the net family assets exceed $50,000. HOTMA has also changed the elderly and disabled deduction, which will be $525, and has excluded educational savings accounts, changed the medical expense threshold, and the public housing mandatory earned income disregard will be eliminated. Again, waiting for regulation from HUD. The section that I previously mentioned that is already in effect is the reasonable accommodation payment standards. So now PHAs can establish, as of the enactment of the legislation in July, PHAs can establish a payment standard up to 120% of the FMR as a reasonable accommodation payment standard. However, exception payments above 120% of FMR for reasonable accommodation purposes still need to be approved by HUD. So the section there on income reviews, a lot of it we still need rulemaking from HUD, so we'll see where that goes. The next section is section 103, which talks about over-income families, income eligibility for public housing. This section has not yet been implemented by required regulations. So again, still waiting for HUD to provide guidance. So the maximum amount of income for continued occupancy for public housing will be 120% of AMI, or another limit set by HUD if they deem necessary through regulation. This only applies to families whose income meets that threshold for 2 consecutive years. So after that happens, after 2 consecutive years, then they are no longer eligible. However, HUD will have PHAs will have the ability to allow the family to maintain their occupancy, and HUD is going to issue guidance on how to calculate the assistance to families, or the amount families have to pay in rent based on their income. Again, HUD has not done that yet. We don't know which direction they're going to go in, so we have to wait and see what their plans are around this policy. So I'm going to move right along to section 104, which has to do with eligibility for assistance based on assets. Again, this section has not yet been implemented by required regulations, but there are two things here. Assets, like I just talked about, in terms of eligibility. If a family has assets above $100,000, they cannot be provided assistance under public housing or HCV. That includes if they have real property that's suitable for occupancy that they have an ownership stake in. Exception here is for families in PHA's home ownership programs, manufactured housing, or victims of domestic violence. Also, families selling the policy that will be subject to this exclusion are exempted from this cap. There are also exclusions in HOTMA to the assets, such as inaccessible trust funds, retirement accounts, settlements for serious for incidents that resulted in serious disabilities, certain tax-protected education savings accounts, and others. Again, we're still waiting for HUD to provide guidance here. The same thing goes for this section here. Starting in fiscal year 2018, PHAs must require all applicants and participants to provide authorization for a PHA to access financial records from financial institutions. This required rulemaking, and although the fiscal year starts in October, without that rulemaking, PHAs will not be able to implement this. PHAs can determine applicants and participants ineligible for assistance if they refuse to provide access to those records. And so that will allow PHAs to better verify family income for the purposes of eligibility. One of the other things HOTMA did was to change the definition of units owned by PHA. This is a small part of the law. But what's important here is this definition might change the status of property currently considered owned or not considered owned by a PHA. So for units that appear no longer to be PHA owned, a housing authority has to get an opinion from its legal counsel, and it has to maintain that opinion in files as appropriate. Additionally, this requirement to obtain an opinion letter from legal counsel applies if changes to the ownership structure in a project result in it no longer meeting the definition of PHA owned. And what that means is that in, say, 3, 4, 5 years, if your PHA has what's considered an ownership stake in a property that meets the new definition and the ownership structure changes in 3 or 4 years, before you can begin to treat that as a non-PHA owned unit, you have to obtain an opinion letter from legal counsel. Section 106 of HOTMA on PHA project-based assistance comprises most of the January notice. Again, being part of the January notice, all this information that I'm going to present is subject to change. But let's get into it. So what are the highlights here? As we go through, we'll flesh these out in detail, but PHA's HCV limit on PBV assistance, that limit has changed from 20% of funding to 20% of units. There is an additional allowance for 10% of units to go towards, to be specifically designated for families with a veteran, families that meet the McKinney-Vento definition of homelessness, or families that include an elderly person or person with a disability. The project unit cap is now changed to the greater of 25 units or 25% of units. The maximum contract term for both initial PBV contracts and extensions is now 20 years. And PHAs and owners are allowed to have a selection preference for families that qualify for voluntary services. So emphasis on voluntary and emphasis also on qualified. Families are not required to participate in services under this selection preference. Two more highlights. PHAs are now able to attach PBV assistance to PHA-owned or controlled structures without competition. And Family Unification Program and HUD vouchers can be project-based. And we'll talk about that later. So as I mentioned in the highlights, the limitation for PBVs is now changed. And with that, PHAs no longer have to submit information on funding or budget authority to HUD. However, as they go forward, PHAs must submit information about, instead of budget authority, concerning the total number of units authorized and committed to PBV, in addition to units that PHAs propose to attach project-based assistance to. I talked about the exception for 10% of additional units. Again, those units must be designated for families that house homeless families, families with veterans, or permanent supportive housing for persons with disabilities or elderly areas. Also, in areas where vouchers are difficult to use. And so I mentioned that term back when I was talking about the difference in how you can treat initial inspections in one of two ways based on the new HOTMA statute. So HUD says that areas where it is difficult to use vouchers are census tracts with poverty rates of 20% or less, according to the most recent American Community Service Survey 5-year estimates, which are published by the Census Department, Census Bureau, and are available on the Census website. Additionally, when we talk about veteran, a PHA can provide further definition to the term veteran for eligibility under this additional 10% allowance. And so some of the things that HUD mentions in this notice are honorable discharges, eligible to receive services from the VA, local VA medical center, and things of that nature. So with that limitation that I talked about earlier, there are units that are not subject to that limitation. That includes units under PBV HAP contract that are not first effective until the effective date of the rule, and also units that meet one of the following conditions in the 5 years prior to the PHA issuing the RFP. And those following conditions are HUD, it being a HUD assisted unit, or being subject to a rent restriction under one of these programs on the right. So on the left, we have the forms of HUD assistance that will qualify a unit for the exception from the 20% rule, and on the right, these are programs that provide rent restrictions that would exempt a unit from the 20% restriction. For a newly constructed unit to qualify for the exception as replacement housing, it has to meet the conditions that I just mentioned. The old units must meet those conditions, but the new units must replace a unit that would have qualified as an existing or rehab unit under either the assistance programs that I just mentioned or the rent restrictions. The new unit must be on the same site of the replaced units, And the new project must be intended to replace affordable rental units at the same site. And HUD says that they'll know if that's the intention based on two things. Former residents are given a selection preference, and also that the project was included in the site's redevelopment plan prior to demolition. Additionally, for new construction and PBV rehab projects, the number of units subject to the exception cannot exceed the number of units being replaced. So if in the old project there were 100 units, in the new project there are 200 units, you cannot accept 200 units from the cap. You can only accept 100 units. So therefore, some units in the project might be subject to the exception, and some units might not be. Projects still must be consistent with your PHA plan and the deconcentration and expanded housing and economic opportunity goals, and all the other kind of goals around the PBV program, goals and regulations around that program. Also accepted are vouchers project-based under RAD and the HUD-PBV set-aside vouchers. Now, this does not include these HUD-PBV vouchers. That doesn't include any HUD-vouchers that the PHAs opt to project-based, only those awarded, specifically awarded through the set-aside funding process. So I talked about the income mixing on the project unit cap, so which is 25% or 25 units in a project, whichever is greater. Accepted from that cap are the following: units serving elderly families, units housing households eligible for supportive services, and then again projects that are in those areas where the HUD has deemed it's hard to use vouchers. Even with the change in limit, owners under current HAP contracts, PBV HAP contracts, are still obligated to the expected number of units in a multifamily project. HUD provides I think, great and easy to understand example here. If an owner has a PBV HAP contract for a 20-unit project, and the project provides that, the contract provides that 15 of those units were exempted from the 25% cap because they are designated for elderly families, the owner must continue to designate those units for occupancy by elderly families, regardless of the fact that the limit on PBV has been increased to 25 units. Of course, unless the PHA and the owner decide to change the terms of the assistance contract. For those first two exceptions there regarding support services and elderly families, PHAs must refer qualifying families for occupancy of those units. And with that second exception there for supportive services, they don't have to be offered on site, but they have to be offered in a way that makes them reasonably available to families receiving the PBV assistance at that project. Lastly, projects that are in the census tract with a poverty rate of 20% or less have a cap of 25 units or 40% of units. So it's not the 25% and 25 units, it's 25 units or 40% of units. There are other exceptions to the project unit cap. Again, I'm not going to go over these in detail. They're in the handout, which will be on the website that you're welcome to view. But in the interest of time, we're going to look a little bit about contracts. So as I mentioned before, the new initial and extension HAP contract term is 20 years. And this applies to contracts that are initiated and executed after this notice goes into effect, and also those that are currently in existence. So I talked about PBV and PBV annual Recertifications are no longer required. Here we see that biannual inspections may be conducted using a random sampling of at least 20% of the PBV units in each building. And so we mentioned in the alternative inspection method, units that are subject to that alternative method in a building in a project such as this that uses sampling, those units don't have to have been sampled, but they had to have been part of the universe of sampling. So that's something interesting to know about how kind of all these policies intertwine. HUD provides initial guidance on PBV contracts about adding units to projects that already have a HEP contract. Additionally, HUD provides guidance on PHAs being required to provide tenant-based vouchers to families if a HEP contract in a project expires. Owners additionally have to allow the family to use the voucher in the unit, but the unit's still subject to HQS and rent reasonable requirements. Additionally, if a family goes from PBV to HCV tenant-based assistance because of the ending of a HAP contract, those families are not considered new admissions to a PHA's HCV program. HOTMA also created some statutes around tenant selection. PHAs may allow owners with PBV contracts to create and maintain site-based waiting lists. HUD has not yet implemented this through a notice and will do so later. PHAs can also establish selection preferences for things that qualify for voluntary services. Again, services are voluntary. Families do not have to participate. HUD, when they talk about voluntary services in this preference selection, the selection preference, HUD is very emphatic about reminding PHAs and owners about their civil rights requirements and non-discrimination requirements. HUD is very concerned with segregation of individuals with disabilities in both the location of project units and the settings in which services are provided. So in exploring this preference, but also in the provision of these services, PHAs and owners have to be cognizant of HUD's desire to see in fair housing requirements that disabled families are fully integrated to the extent possible with families without disabilities. I mentioned before that PHAs can attach PBVs to projects that PHAs have an ownership stake in or a controlling interest in without the competitive process. Here are some regulations about that. The PHA must be engaged in an initiative to improve, develop, or replace a public housing property or site. There's a $1 minimum for hard costs, and the work and the number of units of PBVs being added must be detailed in the PHA plan. I also mentioned that PHAs can project-based HUD VASH vouchers and FUP vouchers. This can happen without additional HUD approval. However, PHAs have to ensure that there can be services from the VA Medical Center for any project-based VASH vouchers. Also, if a PHA wants to designate that only one category of FUP eligible families is able to lease project-based vouchers, they can do that. For instance, if they say only FUP youth or something like that. HUD also wants PHAs to carefully consider if project-basing FUP vouchers is beneficial to that population, or if there will be a challenge in keeping units filled once you attach that PBV assistance for those particular families. There are provisions in the HOTMA that were not implemented relating to project-based vouchers. Those are listed here and include, like I mentioned, establishing the owner-maintained site-based waiting list and also providing rent adjustments using an operating cost factor. So Section 107 deals with the establishment of fair market rent. So the process was changed and was effective rather when HOTMA was enacted. And according to HUD, that process was instituted this last year with this last notification about the change in FMRs. HOTMA, as you see, also changed the regulation around reducing the payment standard of a continually assisted family that's under HAP contract, but PHAs must amend their administrative plan as it concerns that change. Additionally, if the new payment standard causes the family's payment standard to be above 110% of FMR, PHAs must request an exception payment standard from HUD, just like they would if they wanted to implement a program-wide payment standard at 115% of FMR. So PHAs can allow families to keep that higher payment standard as long as they reside in the same unit. Section 108 pertains to the collection of utility data. HUD has not published regulations on how this process will work or selected or determined which areas they will collect and release utility data for. The next section, is 109, and that pertains to public housing capital and operating funds. And again, HUD has not issued guidance for this section of HOTMA, and so I'm just going to touch on a couple of them. Replacement reserves. Funds can be moved from your capital fund into the replacement reserve at any time. If you want to put funds from other sources into the replacement reserve, that requires HUD approval. You cannot have more in the reserve than what is determined as your capital needs, which is contained in the Capital Fund 5-year action plan. Or HUD also has the discretion to select a different amount or a specific amount. When establishing a replacement reserve, any transfer in the amount of more than 20% of the operating fund requires HUD approval. So this repeats what I just said. And we move on to section 110 as we kind of wrap up this webinar. This is going to be the last thing that we touch on. So this section was made effective upon enactment of the legislation, and what it did was change the term of assistance, which is now 36 months instead of 18 months, and that term of assistance applies to youth currently receiving assistance today, as well as obviously youth that were receiving assistance back in July when this legislation was signed. Youth are also eligible up to age 24 now. Youth must be living foster care within 90 days in accordance with a transition plan. And HUD is going to be issuing guidance to improve coordination between PHAs and public child welfare agencies. So the last section of HUD as it pertains to PHAs for HCV or public housing programs can pertain to the use of vouchers for manufactured housing, which again I'm not going to touch on. And then there are additional sections, 113, 114, and 402, that are also effective as of the enactment of the legislation, but are very, the first two are very narrow in terms of the preference for nationals and citizens in Guam for financial assistance. And then Section 114 names housing authorities including the County of Los Angeles, any PHAs in Alaska, Iowa, and Mississippi, which are exempt from the PHA resident board member requirement. However, they have to institute a resident advisory board which meets regularly. So it's not like they're just getting rid of all resident inputs. But I guess the way I read it, especially for states like Alaska or Mississippi that have a lot of rural areas and these large jurisdictions with large geographic kind of responsibilities, it's just making it easier and more feasible to get resident input, but not have to require participation on the same schedule that the board would be meeting. So, as I said when I started out, HOTMA is a wide-ranging piece of legislation. Lots of changes for HQS, lots of changes for the PBV program, but very few changes that are already in effect. We will be on the lookout for HUD notices that detail when the implementation notice from January is going to go into effect, if that comment period is going to be changed, if the effective date is going to be changed. We'll also be looking out to see what other regulations and notices HUD releases for these sections of HOTMA that they did not already release regulations for. And we'll be providing updates. There may be another webinar. And as always, Quadel is ready to provide any kind of consulting services that agencies need. We've today provided an overview. We didn't get into all the details of how policies must be implemented in terms of changing the admin plan, in terms of providing notice to the executive director, the boards of directors, providing notice to HUD. HUD has required some notices to be sent via email. And so there are lots of details that are contained in the notices that once it goes into effect, you'll want to be prepared to implement as intended. And so again, if you have any questions, feel free to contact us. And we hope that this webinar has been helpful, has been useful, and is getting you started thinking about the changes you want to make to your agency to increase operational efficiencies, increase management efficiencies, and help you serve your families better. Thank you very much. And also be on the lookout for other webinars that we are offering, which you can find on our website and training opportunities. Have a great day.